Welcome to week 5 of Legal Issues and Corrections. This week we're going to take a look at First Amendment issues and corrections. This is a continuation of part 2 of the textbook, chapters 7, 8, and 9. We're going to look at inmate mail. This is part of a First Amendment issue because it states that Congress shall have no law that abridges the freedom of speech. And as you know, even outside of prison, First Amendment rights are not absolute. There are restrictions and limitations. You can't scream fire in a crowded theater. And we have judicial decisions to help us determine to what extent liberties could be restricted. So in the prison setting, prison officials saw a need to restrict inmate mail. The primary concern is incoming mail. Letters might contain threats to security, things inside the mail for illegal activities, the discussion of or planning of illegal activities, inflammatory or pornography, or even criticism of the staff. However, this practice of restricting the content of mail could be seen as censorship, and in the prison setting, just the volume of mail that comes through would make it pretty impractical to filter through what is practical. So pretty much what happens is a searching of incoming mail for contraband and identifying those inmates who pose a security risk and paying closer attention to their mail, which obviously can raise some constitutional questions. So the main reason for monitoring those inmates' mail is deterrence. Like I said, incoming mail is of primary importance. It's usually of less concern going out because it doesn't pose a threat to internal security, but it's still important to screen outgoing mail looking for information about potential security breaches, planning of criminal activity, or any particularly upsetting inmate problems. In recent years, there's been a special interest around things like spying, terrorism, things that would be related to national securities. Measures have been enacted to prevent the disclosure of classified information and protect persons against the risk of death or serious bodily injury. Specifically, Title 28, Code of Federal Regulations, Section 5012, 5013, provide more specific information on this area. They basically authorize the implementation of a special administrative measures with respect to these areas of spying, terrorism, and also interviews with representatives of the news media, visitation, use of the telephone. In Procurner versus Martinez, this is a major case, and you're going to find that a lot of these 3 chapters evolve around case analysis, so we talk about a lot of different case names. A California prison regulation that barred inmates from writing letters that unduly complained or magnified grievances. The regulation barred inmates from sending or receiving inappropriate letters. And that would be, criminal activity or anything that would be considered lewd, obscene, inappropriate, and so the inmates filed a class action lawsuit. The court rejected the prison regulations that held the censorship of inmate mail is justified if the regulation in question furthers one or more substantial governmental interest, and the limitation of the First Amendment freedom is no greater than is necessary. And that's, a pretty common test even outside prison. The court found the California regulation to be too broad, too vague, and required procedural safeguards were rejected. Those included notifying inmates, giving the author an opportunity to object, and protest being reviewed by a person other than one who did the initial disapproval. In Navarrete, inmates sued California officials claiming interference with outgoing mail, specifically failed to mail several letters, and the officials claimed qualified immunity. The court held this in a civil rights action under Section 1983. Prison officials are protected against liability. In other words, they receive qualified immunity if, when the conduct complained of took place, there's no established First Amendment right of inmates. The court held that at the time of Navarrete, there was no clearly established constitutional right protecting inmate correspondence. I think if facts arose today in a case, there would probably be a different outcome. Qualified immunity wouldn't be immediately available. The court would have to examine the official's conduct and hold it up against the established constitutional standards on correspondence in procuring urine and succeeding cases. In Turner v. Safely in '87, there were two Missouri regulations under review, one on correspondence between inmates, the other on inmate rights to marry. And the court recognized that running a prison is an inordinately difficult undertaking. It requires expertise, planning, commitment of resources, and the courts are not a good place to deal with problems of prison administration. Said the separation of powers concerns counsel a policy of judicial restraint. So the court held that when prison regulation impinges on an inmate's constitutional rights, the regulation is valid if it's reasonably related to a legitimate and logical interest, and identified 4 factors for assessing that reasonableness. Must be a valid, rational connection between the prisoner regulation and legitimate government interest. And court must look at whether there are alternative means of exercising the right that remain open to prison inmates. The courts must also look at the impact of the accommodation of that asserted constitutional right, and what it will have on inmates, guards, and the general allocation of prison resources. The absence of a ready alternative is evidence of the reasonableness of the prison regulation. In terms of inmate correspondence, Missouri allowed correspondence with immediate family, other institutions, and correspondence between inmates and separate institutions about legal matters, but other correspondence between inmates generally wasn't allowed. So in this 4-part test, number 1, is there a valid, rational connection between the regulation and legitimate government interest? The court said yes. Inmate-to-inmate mail between prisons could communicate escape plans or arrange assaults, retribution, other violence. Number 2, are there alternative means of exercising the right that remains open to inmates? The regulation did not deprive inmates of all means of expression. It applied only to a limited group who posed a particular concern to prison officials. Number 3, what would be the impact of the accommodation on the asserted constitutional right on inmates, on the guards, and the allocation of prison resources? To allow this could result in less safety and security for others, both the inmates and the staff. And number 4, are there ready alternatives? The court found there was no obvious alternative. The court held that the prohibition on correspondence is reasonably related to a valid correctional goal, and the state regulation was found to be constitutionally valid. In the area of inmate marriage, the state regulation did not allow, and prison officials claimed that marriage was not constitutionally protected, and the court didn't agree. The state regulation was held to be an exaggerated response to security concerns of the prison officials, and the regulation was found not to be reasonably related to a legitimate penological interest, which was the test. And so the court held that while the right to marry could be subject to necessary restrictions inherent in confinement, the beneficial elements of marriage are sufficient to form a constitutional protected marital relationship in the prison context. In the 2003 case of Toms v. Taft, the appeals court held the prison had an obligation to assist an inmate in exercising a right to marry, where a refusal to assist frustrates that right. It was an Ohio law that required both parties seeking a marriage license to personally appear in probate court to make application. The state refused, and so the appellate court held such refusal can amount to prison regulation under Turner. There's also been some case law in the area of correspondence in foreign language, except the Supreme Court hasn't addressed it yet. Lower courts have held that when there's translation service available and correspondence has been allowed in other languages, prohibiting some mail in a different language is not allowed. Thornsburg v. Abbott, in his '89 case, it concerned the receipt of publications, magazines, newspapers, books, etc. It was a federal prison regulation, allowed inmates to receive outside publications, but allowed prison officials to reject if they found it was detrimental to security, good order, discipline. They could not reject on such grounds as religious, philosophical, political, social, or sexual content, or if the content was unpopular or repugnant. So some examples of publications that could be disallowed: publications depicting homosexuality and some other sexually explicit material. And so inmates and other publishers challenged those prohibitions, and the court held that the applicable standard was Turner, and ruled the regulations were reasonably related to a legitimate penological interest, which specifically was prison security, and that there was no obvious alternative. And Bell versus Wolfish in '79. This is a case primarily known for dealing with jail conditions. Also, it had a male aspect to it. The male aspect dealt with requiring inmates to receive publications only from the publisher. The basis for that rule was also security, and the idea that contraband is less likely to be secreted in during publications from a publisher. The court found that regulation to be reasonable, noting that it was an obvious security concern, that there were other ways for inmates to obtain reading material, including prison library, and it was content-neutral regulation. In terms of inmate postage, the appeals courts have held that prison officials may limit, for non-legal mail, the number of stamps given to an inmate, and may also limit the number of stamps that an inmate may purchase or possess. In the case of nude photos, the lower courts have upheld bans on nude photos of wives and girlfriends, basically for security reasons around the potential for violent altercations. Chapter 8 continues in the First Amendment area, looking specifically at inmate association rights and visiting. There's two types of association rights protected by the Constitution, and you can see this in the Roberts v. USJC's case in 1984. The right to enter into and maintain certain intimate relationships, and the right to engage in expressive association, to speak, to worship, to petition the government. Jones v. North Carolina Prisoners Labor Union, 1977. This is a labor union was formed in North Carolina. The purpose was to seek through collective bargaining to improve working conditions, work towards elimination of certain correctional practices, and serve as a means for presentation or resolution of grievances. The state initially allowed it. As it grew, the department issued a regulation prohibiting the solicitation of members, banning the union meetings in prison, and forbidding bulk mailings about the union from outside sources. And of course, the union sued under Section 1983. The court upheld the state regulation and said associational rights may be limited by prison official concerns about prison order and stability, and noted that the lower court did not give appropriate deference to the decisions of prison administrators. Court said the needs of a prison's ability to impose limitation in constitutional rights, even in areas of the First Amendment, that there has to be some limitation or it could cause friction. And the court saw this regulation is not only reasonable but necessary for officials to control these union activities. They also said there's no valid equal protection issue. Prison officials had reasonable grounds for distinguishing labor unions from permissive groups like the AA and Boy Scouts. Their AA would be an example of something that's non-adversarial, and basically said the prison is not a public forum. And inmates in news media area, there's the Pell v. Pecuniar and Saxby case, and the Pell case, California regulation that barred face-to-face interviews between individual inmates and news media representatives. The inmates and the media representatives sued, arguing it was a violation of freedom of press. The court in Pell upheld the regulation after looking at the two sets of issues presented by the two parties, the inmates and the press. On a claim of restriction of the inmates' First Amendment rights, the inmates had alternative means of communicating, including correspondence with the news media, families, attorneys. They were ensuring that the inmates had an ability to communicate complaints or grievances. The media's claim that the limitations violated the right under the freedom of the press, which is guaranteed in the First Amendment, extended to the states by the 14th Amendment. The court noted press could still visit and take tours of the prisons and speak with inmates they encountered and discuss with them any subject. Individual inmate restriction intended to prevent individual inmates from becoming public figures and gaining notoriety and influence among other inmates. In the Saxby case, the federal system had a similar ban on individual interviews based on a big wheel theory, and the court acknowledged that prison concerns of not wanting to create tension were sufficient. The court's holding, however, was strictly a legal one. Members of the news media have no more constitutional right of access to prisons or their inmates than anybody of the general public. And the court applied this constitutional standard to the California regulation that held the press was given access to information available to the general public, and thus there is no First Amendment violation. The Pell and Saxby decisions are noteworthy for their support they give to prison security and good order and against strong First Amendment claims. These type of regulations are important for orderly operation of prisons to prevent threats to unrest and prevent animosity. The theory is that special attention can bring special notoriety within the prison, and that can lead to hostility, to pressure, or perhaps even staff treating somebody differently. The Hodgkins VQ KQED case, the Garrett case, and the Smith v. Coughlin case. This is kind of a look at press visitation. The Hodgkins case, sheriff refused to allow press to visit and photograph a portion of a county jail where the inmate had committed suicide and where the conditions allegedly were bad. And the court reaffirmed Pell and Saxby and said there was no greater right of access. In the Garrett case, that concerned filming and televising executions. The Federal Appeals Court upheld Texas rule excluding news media from filming them. The holding reaffirmed in 2001 in Indiana District Court case involving the execution of Timothy McVeigh saying the press had no constitutional right of access beyond that given to the general public. The Smith case, the Court of Appeals upheld a state restriction on visits with death row inmates, which limited visitation to family members only. In the area of inmate visits, there's some issues that come up. In terms of visiting lists, prison officials will review them. Names that are submitted by the inmate, maybe background checks. Some prisons also require inmate correspondence and telephone lists. There's usually two types of contact, visits, contact and non-contact. And the main concern of prison officials in this area is passing contraband. And here's some steps to avoid passing of contraband. In the Block v. Rutherford case, the jail policy allowed only non-contact visits by pretrial detainees with their spouse, relatives, and friends. So there's a class action suit under 1983. The court upheld the policy, saying that prohibition reasonably related to legitimate governmental interest, and that there's no constitutional requirement for contact visits. In the Kentucky Department of Corrections v. Thompson case, there was a Kentucky regulation that excluded certain prison visitors, and that list is seen on the slide. Again, the inmates brought a class action under 1983, saying it was a violation of due process under the Constitution also to terminate or suspend visiting without any kind of hearing. The court held that for a due process claim there has to be a liberty interest, and this could be found in either the due process clause of the Constitution or laws of the state, and held that neither of those were present. As to the Constitution, the suspension of visiting privileges was not guaranteed by the due process clause. The court noted that in the prior case it had rejected the idea that any changes in conditions of confinement that adversely affected inmates were sufficient to invoke due process simply because of that adverse impact. As to the regulatory aspect, the Kentucky regulation stated administrative staff reserves the right to allow or disallow visits. The state language was more of a guide, a substantive predicate versus a requirement, which would be an explicit mandatory language. The court analysis in Thompson brought into doubt by later court decisions in Sandin in 95. The court came close to, but did not address the issue of whether there was a constitutional right to visit. The majority opinion infers that if there were sound security reasons, a ban would probably be constitutional. In Overton versus Bezzetta in 2003, a little history, in the 1990s, prisons in Michigan, the population was increasing, leading to increase in visitation, straining the prison resources, and the prison officials found it more difficult to maintain order during visiting and to prevent smuggling or drug trafficking. And so Michigan implemented regulation limiting who could visit, including limiting visits by an inmate's children and placing other restrictions on the visits. The inmates, their friends, families sued under Section 1983. They alleged violation of the First, 8th, and 14th Amendment. The case focused on non-contact visiting, and the court upheld prison regulations against First Amendment challenges to freedom of association. The court also held that there's no violation of 8th or 14th Amendments. In terms of conjugal visits, it's allowed in a few states. There's little constitutional law on the subject, and there hasn't been a Supreme Court ruling on it. I know that states like California, Connecticut, Mississippi, New Mexico, New York, I think even Washington allow these types of visits. A federal district court has held no constitutional right exists, saying that it's not excessive punishment to disallow them. Like I said earlier, courts in New York have ruled that visiting policies with within the discretion of the prison officials who could allow or limit conjugal visits to spouses. Some of these cases even go into the area of artificial insemination. There's only a few legal cases on it. The Turner Standard applied in those cases, with court holding that a request for artificial insemination may be denied based on legitimate penological concerns. As an example, the Gerber v. Hickman case, there was a 41-year-old inmate serving 100 years to life, plus 11 years, want to be able to allow to ejaculate into a plastic collection container and have it sent to the lab. And he said he would be willing to pay all the costs. The Court of Appeals affirmed the lower court's denial and said the right to marry provided in Turner does not include this right to consummate the marriage. 1990 appeals court case, Goodwin v. Turner, denied a Bureau of Prisons male inmate's request to procreate. The court said if it was to require this, a corresponding benefit would have to be provided for female inmates, and this would require an expansion of medical services, impose an additional financial burden on added infant care. There's just a lot of ramifications of that. In Chapter 9, we conclude our study of First Amendment issues with religion, and specifically the Establishment and Free Exercise Clauses. So the Constitution doesn't require a complete separation of church and state. Instead, there are tests under Establishment and Free Exercise Clauses. You see this like in situations where persons are handing out religious materials in an airport, not serving in the military, different things like that. In the establishment of religion, the clause prohibits any action by the government to establish religion, and that doesn't frequently happen. There's only a few issues in prison that have litigated that part of freedom of religion. And the federal courts have upheld the use of federal money to pay prison chaplains to build chapels and to buy religious materials. In Everson versus Board of Education, the court said the Establishment Clause means at least this, that neither state nor federal government can set up a church, and neither can pass laws which aid one or prefer a religion over another. Neither can force nor influence persons to go or to remain away from church or take part in, openly or secretly, in affairs of a religious organization or group. In Bowen v. Kendrick in '88, the Supreme Court held that if both secular and religious objectives influence the government's practice, there's no violation. Then there's these faith-based initiatives that are kind of talked about separately from religion, but related to. An executive order issued by President Bush provided for faith-based initiatives. Those supporters of that effort believed that initiatives would help an inmate prepare for successful community return. Prison litigation arose around the initiatives because there's an implication of the Establishment Clause. Cruz v. Beto, 2000, actually it's in 1972. A Texas inmate filed a 1983 action claiming to be a Buddhist. He objected to other religious programs that provided Jewish and Christian Bibles. He claimed he was not allowed to use the prison chapel, correspond with Buddhist religious advisors or share religious materials. For his attempts to hand out the materials, he was put in solitary confinement. Court ruled that the inmate would have to be given the opportunity to pursue his faith comparably to other inmates and other religions. There is litigation brought by black Muslim inmates in the early 60s that can be credited with opening up the federal courts to inmate civil rights claims. The claims were made for groups to be recognized and to allow religious activities. Courts have been reluctant to tackle issues of what is, in fact, a religion. In Fullwood v. Clemmer, the district court concluded that black Muslim faith was indeed a religion, and tied religion to a belief in the existence of a supreme being controlling the destiny of man. In Olone v. Shabazz, there was a New Jersey regulation prohibiting inmates who were working on outside work details from coming back inside the prison during the day, except for emergencies, and that regulation was due to security concerns and demands on staff. And the prison inmates who were Muslim argued that it would affect their ability to exercise their religious beliefs. The Court of Appeals found the violation of the inmates' free exercise rights would have required prison officials to show there was no reasonable method to accommodate inmates' rights to observe a central religious practice. The Supreme Court reversed, upholding the prison officials and the regulation, and said that the court should afford deference to prison officials, held that the prison officials acted reasonably, and that their objective outweighed the inmates' First Amendment claim. The Religious Freedom Restoration Act, the Olone standard was called into question following the 93 enactment of the Act. The Act says the government may substantially burden a person's free exercise of religion only if it's necessary to further a compelling governmental interest, and it's the least restrictive means of doing it. And it applied to prison administrators. In the City of Bourne versus Flores case, a local zoning official in Texas denied a religious leader a building permit to enlarge a church. The church's Archbishop sued, challenging the denial of it under the RFRA, and the case ended up at the Supreme Court. The court held that the RFRA exceeded congressional power. Congress does not enforce a constitutional right by changing what the right is. It's been given specific powers under the Constitution, and that the power to interpret the Constitution remains with the courts. So the federal government interpreted Bourne as applying only to the states, and thus the RFRA is still applicable to the federal government. In 2000, Congress passed the Religious Land Use and Institutionalization Persons Act. This act keeps the compelling governmental interest standard, a least restrictive test, but narrows the scope of its application. Focuses on the protection of land use when used for religious exercise and protection of religious exercise by institutionalized persons. As to institutionalized persons, the Act applies where the substantial burden on the religious activity occurs in a program or activity that receives federal financial assistance or would affect commerce with foreign nations among the several states or with Indian tribes. That's the Commerce Clause. Lower court split on the constitutionality of the Act. In a Cutter v. Wilkinson case, Ohio inmates claimed the denial of a right to religious practice due to what they saw as an unwarranted security concern in violation of the Act. And as of this time, there's no Supreme Court decision on the RLUIPA. Other free exercise issues in prison, diet, that's a big one. Some religious groups have strict dietary requirements in the 60s and 70s. Most of those related to things like pork-free for Muslim inmates, kosher for Jewish inmates. It's been very difficult to base their provision of such special religious items as diet on the sincerity or orthodoxy of the inmate's belief. Some factors that may be asked or looked at are whether the inmate takes part in other religious observances at the prison, whether the inmate eats food that is not consistent with his religious belief, and whether the inmate purchases commissary items contrary to their religious belief. It's not permissible to make a finding based on a determination that the inmate's beliefs fall outside the main or customary tenets of the stated religion. The number of different religions with special dietary needs can impose a large burden on correction facilities that tries to accommodate such demands. There's some cases and some examples of this. I'm not going to go through all of those cases, just kind of give you an idea that, look at those cases in terms of what kind of issues came up in them. So as you can see, a number of these different religions can pose special dietary needs, and corrections agency has to balance all these various demands in terms of preparation, verifying all this. Grooming, again, that's tied to free exercise, and that some religions require different different practices in terms of hair, being clean shaven or not, and that might be contrary to security, sanitation, or appearance concerns. And those cases have gone both ways. And there's some examples of cases that a no beard rule was an impermissible infringement, and other cases where cutting hair was supposed to be sacred, and cutting it would be against one's religious beliefs. And as with the religious diet cases, the Supreme Court hasn't ruled on inmates' complaints in this area. There's also some issues around what truly is a religion in some unusual religious groups. And then the issue is, would those activities or religion pose a threat to the prison order, security, or pose a burden on prison administration. An example is a Court of Appeals case, McCorkle versus Johnson. Inmate filed a 1983 suit claiming prison officials violated his constitutional rights to exercise his satanic religion. The state first argued that Satanism wasn't a religion, and the inmate was not a sincere believer. And the court refused to get involved in those issues. The court said even if Satanism is a religion and it was sincerely held, state policy was valid because it was reasonably needed, primarily because of the things that the inmate testified, in terms of wanting to practice sacrifice, draw human blood, eat human flesh. So you can see there's a variety of issues that come up in the free exercise area.